In the matter of Vishnu Vardhan versus the state of Uttar Pradesh, Supreme Court set aside order of High Court as fraud had vitiated entire proceedings. The court also recalled judgment of Reddy Viranna case by exercising its inherent powers. Fraud unravels everything was famously said by Lord Denning in Lazarus Estates Limited versus Beasley, emphasizing that fraud can invalidate judgments, contracts, and all transactions. The principle highlights the importance of honesty and transparency in legal proceedings and transactions. However, it is cardinal principle of law that fraud has to be pleaded and proved. Order 6 Rule 4 of the Civil Procedure Code 1908 may be referred to ordaining that particulars inter alia of fraud have to be stated in the pleadings. From multiple decisions of the court on fraud, what follows is that fraud and justice cannot dwell together. The legislature never intends to guard fraud. The question of limitation to excess power does not arise if fraud is proved, and even finality of litigation cannot be pressed into service to absurd limits when a fraud is unraveled. The present list concerns rival claims in respect of ownership of a land situated in Gautam Budh Nagar, Uttar Pradesh, which was acquired by the new Okhla Industrial Development Authority in 2005 and now forms a part of Sector 18 Noida. The land was jointly purchased in 1997 by Reddy, 1T Sudhakar and Vishnu. Relying on their joint ownership, Trio initiated various legal proceedings seeking multiple relief from time to time before and after the acquisition of land by Noida. Court held that in the event of non-cooperation from side of Reddy, High Court may pass such restraining order as it may deem fit and proper. It further said that having regard to magnitude of fraud which we have detected in course of consideration of these proceedings, we find it just and proper to request Chief Justice of High Court to preside over division bench for finally deciding writ petition as early as possible and subject to convenience of the bench, preferably by year end. Considering Reddy's consistent stance in earlier proceedings that property was jointly owned with Vishnu and Sudhakar, his failure to implead them in writ petition is appalling, if not more. Court said, in our view, it was a calculated attempt by Reddy to wrongfully appropriate entire property, keeping the other two, Vishnu and Sudhakar, in the dark. Writ jurisdiction in India is, as is well known, emanates from two articles of Constitution, Article 32 and 226. The latter pertains to writ jurisdiction exercisable by various high courts in the country, while former confers jurisdiction on Supreme Court to issue writs, orders, directions for enforcement of fundamental rights granted by the Constitution. Since the high courts are empowered under the Constitution to enforce legal rights apart from fundamental rights, power conferred under Article 226 is considered to be more expansive compared to the power under Article 32. The right to seek effective legal remedy for an infringed right is part of right to life enshrined under Article 21 of Constitution. Since 1970s, interpretation of Constitution, particularly fundamental rights, has undergone significant transformation. Through dynamic and evolving interpretations, various aspects of equality, life, and freedom have been recognized and expanded to reflect the changing needs of the society. Article 14's guarantee against arbitrariness is fundamental to all state actions. Since equality and natural justice are antitheses of arbitrariness, nowadays it has become customary to style a petition as one filed under Article 32 and vaguely allege either arbitrariness or violation of traditional principles of natural justice. The rules that none should be condemned unheard or no one should be judged of his own cause, as well as third principle developed in India, which also includes the right to be afforded a fair hearing and a reasoned order should the outcome of the proceedings be adverse to the person proceeded against. Question is, should the Supreme Court entertain writ petitions under Article 32 without clear and specific pleadings as to how the right to equality or any other fundamental right has been infringed and what is the impact thereof on the suitor without clear, specific, and definite pleadings? The answer must be an emphatic no. If the principles deducible from the authorities referred to above are of any guidance and help, a loosely drafted writ petition under Article 32 ought not to be entertained in absence of requisite pleadings, even where violation of statutory right is to be camouflaged as violation of a fundamental right or where a statutory right is found to have been predominantly violated with only an incidental infringement of a fundamental right. The court may, in judicious exercise of its discretion, refuse to entertain writ petition while safeguarding liberty of the suitor to pursue his writ remedy before the High Court under Article 226 of the Constitution. prioritizing justice and fairness should supersede an absolute insistence on finality. While the latter is commendable, the former is superior. On a conspectus of authorities, court was inclined to view that the doctrine of merger may not have any application in all cases of cognate civil appeals being carried from the same order if it is convincingly demonstrated that his right of appeal should not be foreclosed because of very rare or special circumstances that are projected before court, or his appeal raises an issue of seminal public importance which was not available to be raised by appellant who approached the court in appellate jurisdiction in earlier round of litigation, and also that such issue in greater public interest requires a resolution by the court, or since an act of court ought to prejudice none, refusal to interfere by the court would invariably result in offending principle of actus curiae neminem gravebit, or the earlier appellate decision is vitiated because of fraud having been practiced on the court by party in whose favor ruling had been made, as in this case, or that public interest would be put to extreme jeopardy by reason of irretrievable consequences ensuing if interference which is otherwise found to be warranted in law were declined solely on the basis of doctrine of merger. Court said that procedural law is a sentinel of non-arbitrariness. It not only provides a safeguards against the individual vagaries of a judge, but also establishes structured framework for litigants to approach legal system for redressal of their issues. However, procedural law cannot foresee all situations that may arise. Procedure must facilitate justice, not detract from it. In special cases, the letter of procedural law must yield to the ends of justice. Courts are, of course, duty bound to apply procedural law in its entirety, save where such application would result in manifest absurdity.